At TVC News, wherever the big news story is happening, we're geared up to break it. TVC News, first with breaking news.
Good morning, and thank you very much for joining us. I am Yori Folani. Okay, I'll tell you what. This morning we thought we'd delve a bit more into the law. You know, maybe I should just say a bit more into the law, in the sense that from time to time the public gets to hear about some quote-unquote arcane aspects of the law. That is to say, matters that the general public doesn't necessarily know very much about, but then the learned community is all too aware of those matters. I'm talking here about jurisdictional excesses, judges and jurisdictional excesses. We're very fortunate in the sense that we have an expert. So I'm not even going to bother with my own dictionary references, legal dictionary references as to what exactly are jurisdictional excesses. There's no need for that because we have an expert in the house. He's well known to you, who will be explaining, number one, the meaning of the term, and number two, the extent to which it is prevalent in our society. I'm talking about Barrister Wahab Shittu, S.A.N., constitutional lawyer. Good morning, Barrister Shittu. It's good to see you again.
Thank you for inviting me, Uncle Yori.
Our pleasure, always, sir. So this concept of, jurisdictional excesses, it also necessarily brings judges on board, because until a judge has animated a process of the court, the court just exists there. You can't really say that something has happened. So we wanted to find out, in the light of some things that have been happening, number one, from you, maybe let's start this way. How would you describe a jurisdictional excess in the first instance? And then two, to what extent, how prevalent is it in our society? Maybe I'll just start like that.
Thank you, Uncle Yori.
Very welcome,
and
sir.
my pleasure to be here. Now, to go straight to the point, when we refer to jurisdiction of a court to adjudicate over a matter, what we are saying is that is the power of the court, the competence of a court to entertain the subject matter, the power.
As in the authority.
The authority of the court.
Okay.
It is not in all cases that a particular court has power or authority to entertain a matter.
Okay.
Not so. There are various and the Constitution and our laws have envisaged this. When you act outside the authority that the law donates to you to exercise, to adjudicate over a matter, you are said to have acted in excess of jurisdiction or acted without jurisdiction.
Okay. Which is a legal excess of jurisdiction.
Yes.
Is a quaint
it means that you don't have the power to entertain that subject matter. Nevertheless, you proceeded to do so.
Okay.
You don't have the authority to entertain that matter. Nevertheless, you proceeded to do so.
Okay, so
that is simple. So power, authority to preside over that matter is, and then there are various types of jurisdiction.
Okay.
And it's very important. The law envisages a situation where a jurisdiction is expressly donated to you. Or
by the law?
By the law.
Okay.
And there are situations where a power is donated to you by virtue of the fact that you are a court. You have certain inherent powers.
Okay.
For instance, as a court, you have inherent powers to adjourn a matter.
Okay.
You have inherent powers to determine whether you have jurisdiction over a matter.
Okay.
Okay. So those are inherent powers. So sometimes jurisdiction can be seen in terms of there are certain courts that have exclusive jurisdiction. It means that you cannot. It is only that court alone that can entertain the matter, and no other court.
Okay. Well, thank you, Barrister Shittu, for bringing in that matter about different kinds of jurisdiction.
Yes.
And so to that extent, a layman might see it as, Oh, this is a technical issue because you have to know exactly in what field you are playing in order to know what the jurisdiction is. You just explained that there are some that have exclusive jurisdiction.
That's why you are the expert. If you are a lawyer, you must have gone through certain training. You will have been taken through all the courts and the powers they have.
Thank you.
And so when a subject matter is brought before you, you know which court to approach.
Okay. Now, this exactly brings me up to the next question I was going to ask. You must be an expert. You would have been trained by the law. Yes. Now, I imagine that very few lawyers are more so than their lordships themselves, who actually are judges. And our caption here is judges and jurisdictional excesses. Why does it happen? Why does it happen at all when we have such experts at the head of a court who know better than most what the limit of their jurisdiction is? Why do we have instances like this where it often manifests to the ordinary member of the public in, a court of appeal in Abuja has overturned, a position of a court in a state? Why does it happen with such experts in charge?
Well, there are various reasons for this. Sometimes you might not be able to blame the court.
Okay, how is that?
Because in some situations, we do not have clarity about the court that actually has jurisdiction over that subject.
Really?
Yes.
It's a problem with lawyers.
Yes.
They don't always know clearly.
Sometimes there's no clarity.
I see.
For instance, in fundamental rights, situations.
You just threw in a legalism there. Fundamental rights.
Yeah, fundamental rights.
Oh, rights.
Yeah.
Okay. Yes.
Fundamental rights.
Okay. Yeah.
Actions,
human rights.
Human rights actions. There are two courts that have jurisdiction to entertain it. Concurrent jurisdiction, we call it, because both of them have powers to entertain matters of fundamental rights.
Okay.
Federal High Court and a state High Court.
Okay.
But these powers are also limited by the subject matter giving rise to the fundamental rights. For instance, if the subject matter is chieftaincy matter, and you are talking of enforcing your rights over a chieftaincy matter, clearly the Federal High Court does not have jurisdiction.
Does not?
Does not.
Okay.
It is a state High Court that has that jurisdiction.
So you can't...
So even though it is a fundamental rights claim, but because it arose from a chieftaincy matter, which is exclusively reserved for a state High Court, the Federal High Court cannot entertain the matter. So in situations like that, there's clarity. There are settled pronouncements of our courts, higher courts. Supreme Court have pronounced repeatedly.
So a federal court of appeal is unlikely to engage in a matter of chieftaincy.
Chieftaincy matter.
It's just...
Even land matter.
Okay.
Even issue cases like murder cases. You don't go and charge somebody for murder in the Federal High Court.
Okay.
Murder is a state offense. It's reserved for a state High Court. You understand what I'm saying?
Yes.
So, and issues of chieftaincy is a state matter.
Okay.
So you don't take that to Federal High Court. But you see, matters that Federal High Court can entertain exclusively are defined by Section 251 of the Constitution. And they are juicy matters, bankruptcy matters, revenue of the Federation, and all that. They are listed there.
How about, you said that there isn't always clarity.
So for instance, if somebody is saying, there's a land dispute, and there is a threat to life and all those things arising from that land issue, you want to say, okay, land issue is to be handled by the state High Court. But the man is talking that, my fundamental rights have been infringed upon. He brings it in such a way, he doesn't, he disguises the nature of what is actually, it's a land dispute. But he's saying that he's trying to make it look like a fundamental rights enforcement action in order to disguise the nature of the action.
And get the matter before a high court.
And get the matter before the Federal High Court. So the Federal High Court judge has to look with his legal binoculars on the claim. They will look at the claim. Is this not a land matter disguising as a fundamental rights case? In which case I don't have jurisdiction.
And so when the Federal High Court pronounces upon it, is that the end of it, or it can still be pursued up to the Supreme Court?
It can be pursued up to the Supreme Court. You see, let me also make some clarity. Every court has jurisdiction to be right, as well as jurisdiction to be wrong. You understand me? It means that, so what I'm saying is that if a judge exercises powers or authority over a case in which he does not have jurisdiction and makes a pronouncement, that pronouncement is valid
until
set aside. And this is why we need to be very careful. We shouldn't bring the administration of justice into manifest ridicule. A judge is somebody that is vested with some powers. A judge represents the authority of our judiciary. And we should be, so court orders should not be treated with levity. You say, oh, because that court has issued an order which you know is in excess of jurisdiction, then you obey it. You don't have that kind of powers. Once an order has been made by a court, whether in furtherance to jurisdiction or in excess of jurisdiction, you have a duty as a government, as an authority, as an agency, as an individual, to obey the order. If you are aggrieved with the order, the option you have is an appeal. And the law envisages that judges can make mistakes. A judge sitting as a single judge can make mistakes because he's human.
You know, thank you very much, Barrister Shittu. And why this was necessary for non-legal minds to understand all of this is that there have been a number of instances. As you were speaking, my mind went to, for instance, the situation in Kano. You might refer to that as a chieftaincy affair. You then look at a totally different matter, the situation in Rivers State, where recently a court has voided the sack of Rivers Assembly Speaker Amewule and 24 other people. Now, you had explained that there isn't always clarity. But in this case, the case of Rivers State, the judge has voided it, and when you void a matter, it means that all actions taken when that matter was thought to be good, it had not been affected by a pronouncement of a superior court judge, then all those things that were purported to have been done, the law sees them as not having happened.
Yes. The Court of Appeals voided what the State High Court did and said the State High Court had no jurisdiction.
Exactly. So had no jurisdiction.
So when you have no jurisdiction, you lack competence to make any orders.
And so where does that actually leave the situation? Because it is the most current. There are other instances, but it's the most current. All of this happened, somewhere around July 3 or 4. Where does this now leave the situation in Rivers State, where 25 members of the Rivers State House of Assembly are said to have lost their seats?
Well, by the clear pronouncement of the Court of Appeal, they have not lost their seats. Because they said the court has decided that they have lost their seat. Does not have jurisdiction to make such a pronouncement.
And so the implication of...
is a status quo.
Yes.
Antebellum. Oppress. What was there? What happened before they went to court? Is not the situation.
So they have not lost their
seats. They have not lost their seats.
Does that then follow logically that all the things that were done at the time when the pronouncement was made that they had lost their seat do not stand and cannot stand?
They do not stand and cannot stand. And if anybody is now proceeding that they stand, that person is acting unconstitutionally.
Now, going...
You understand what I'm saying?
I do.
You see, and this is the point we have to make. We operate a democracy by the rule of law, not a democracy by the rule of jungle. And if you are the jungle, so if, for instance, you go to court, and then a court that does not have jurisdiction to entertain your matter assume jurisdiction and makes an order, you have to obey the order. If you are aggrieved, the mechanism open to you is to appeal. Until that order is set aside, that order that was made, even by inquiry, in ignorance of the law, is still the valid order. Why the law adopts that kind of approach is that you don't say because a court has issued an order without jurisdiction, you obey it.
Okay.
You must obey it.
Okay.
You must obey it.
You must
if indeed you are in a democracy governed by the rule of law. Otherwise, anarchy will resume.
So you obey first.
Obey. If you are aggrieved, the options open to you is to stay the order. Ask the same court to stay the execution of the order. You bring the formal application before the same court. I want to appeal, or have appealed. Stay the order. The court that has made the order can stay it or refuse to stay it. If the court refuses to stay it, you go to the court of appeal to ask for a similar prayer. Court of appeal, stay that order because I've appealed. And until that order is stayed by an express pronouncement, you have to obey. Now that the court of appeal has said the seat in Rivers State is not vacant.
It's not vacant.
Everybody, the governor of Rivers State, all institutions in Rivers State, all lovers of democracy must respect that order. If they agree, if they are dissatisfied, the option open to them is to appeal to the Supreme Court and try to stay the order.
So
without that order being stayed, without that order being set aside by the court by the Supreme Court, it is still the order. So technically, the speakers, the 27 members remain members of the Rivers State House of Assembly. Their seats are not vacant.
When you say technically,
I mean,
is it not
legally,
and therefore factually?
Factually, yes. They remain members of the Rivers State House of Assembly. The order, their seats remain not vacant.
Even though some of the issues of contention was one, it was said at the time that because these members have decamped to another party, therefore this fate has befallen them. That was the position that was put forward.
It doesn't arise automatically. You must get an express order to declare a seat vacant. Otherwise, anarchy will resume. Everybody will become a pocket lawyer. Everybody will begin to interpret the law. No. If you want given situations to arise by law, then you must get specific legal pronouncement.
And to the best of your knowledge, this wasn't obtained.
Yes, it wasn't obtained. Yes. You must go to court to say, these people have defected. By reason of that defection, court declared a seat vacant. If the court now makes that kind of pronouncement, it becomes valid. But it doesn't arise by conjecture. Okay. It doesn't automatically arise.
I hear you, sir.
Yes.
Now, in order to understand it a bit better, maybe you could sort of flip this onto a different jurisdiction, go to Kano State, for example, and look at what happened in Kano State.
Yeah, what happened in Kano State, with due respect to the Judas, clearly it's a chieftaincy matter.
When you said with respect to the Judex,
Judas, with due respect to the judge.
Oh, okay.
Who has made the pronouncement.
Yeah, we just need to remember that most of us are...
to the judge.
Okay.
That has made...
Okay.
My humble view is that the orders made by that judge was outside jurisdiction.
It was outside his...
It was without jurisdiction. Because we are dealing with a chieftaincy matter.
Yes.
For which the Federal High Court has no jurisdiction to entertain. So you cannot be talking of, because the claim for fundamental rights is ancillary. It's not the main claim.
It isn't.
The main claim is chieftaincy. If you are not talking of enforcement of rights arising from a chieftaincy matter, then you cannot litigate that matter in the Federal High Court. But having said that, Justice Liman has made the order, whether rightly or wrongly.
And
all institutions must obey that order.
And that's
the governor of Kano State and all of them must obey that order. If they are aggrieved, the option open to them is to appeal and seek to set aside the order. It's not for it does not lie in the mouth of anyone, including the governor, to say no because that order was out of jurisdiction. Who obey it? No. No, you have to obey it.
So
then proceed to the Court of Appeal to get it set aside. And until it is set aside, Justice Liman's order is the law.
And Justice Liman's order, well, unless you want to come by way of infringement of rights.
If you are talking of infringement of rights arising from a chieftaincy matter, the Federal High Court does not have jurisdiction.
So where does this leave exactly the situation in Kano where the emir has been returned and put back on his seat? That again...
Returning the emir.
Yes.
Returning the emir, Emir Sanusi.
Yes.
without Mohammed Sanusi, without getting the order of the Federal High Court, even if made without jurisdiction, without getting it set aside, is illegal.
Illegal.
Illegal. So Justice Sanusi's remedy lies, Emir Sanusi's remedy lies in trying to set aside the order of Liman.
Are you aware that there's any such process?
I think they have appealed. Okay. And the fact that an appeal has been filed does not automatically set aside that order. There must be a clear pronouncement by the Court of Appeal overruling what Liman has said. So Liman's order remains the law now, even without jurisdiction, because he has jurisdiction as a judge to be right, as well as jurisdiction to be wrong. If you think he is wrong, go to the higher court to set it aside.
Okay.
So as it is now, the effective emir, the status quo ante bellum in Kano remains. The former emir remains the emir, because of Liman's order, even though made without jurisdiction, until that order is set aside. Even though I can talk to you, I'm very positive that that order will be set aside. But until that is done, we must not enthrone a regime of anarchy. We must always give fidelity to the law, respect to the law. We are operating democracy by the rule of law, not by the rule of jungle. Well, so we must respect the orders made by Justice Liman until it is set aside by the Court of Appeal.
So let me, because of where we've got to now, we've compared two different cases, and you've explained how this whole matter about the jurisdictional excesses might apply. One, how widespread is this? I've just taken two instances. How widespread is this in your knowledge, where the principle of a judge is allowed to be right and is also allowed to be wrong, and it will be resolved, judicially, because we can't have the society degenerate to a lawless society where everybody just does what they want. There are certain conventions. They might not satisfy you, but there are conventions of those who live under the rule of law.
Uncle Yori, I must be frank to you, it is pervasive. It is pervasive and pervasively worrisome. And that is why we must begin to emphasize the quality of appointments into our. And then we must try to insulate judiciary from political interference.
Okay.
We should allow the judges to do his job professionally, the way it can be done. And the other way to also reduce these incidents is to fast-track our justice delivery system. When you go to court and the court exercises a jurisdiction that it does not have, a mechanism must be put in place that this can be corrected within a very short time. For instance, the Kano matter, even if anybody will say that it's a chieftaincy matter and that Justice Liman may have issued the order without a jurisdiction, it should have been resolved by now by the Court of Appeal. Exactly. There shouldn't be any, because it's something that is capable of causing chaos. Particularly since we have a state government that is saying we have a right to determine the subject matter. Who is the emir? The former emir Sanusi was dethroned by the actions of a governor. This situation did not arise. So there must be a mechanism that we put in place that will fast track.
Yes.
Whether this mechanism can arise by ensuring that more justices are appointed, more courtrooms are built, that will strengthen the capacity of our judges through training and retraining, and then we ensure that the best of our brains go to the bench.
Okay. One moment, sir. Mr. George, good morning. Thank you for calling in. Quickly before we go on break then.
Good morning, and good morning to Mr. Shittu.
Yes. Good morning. Good morning.
Uncle Yori, there's one question I want to ask Mr. Shittu. These judges, when you bring cases before them, they knew from the beginning that such cases do not fall within their jurisdiction. Why did they decide to sit on it? And then the other party will come and contest it before we now know which court has jurisdiction. The whole thing is becoming like a business.
Okay, thank you very much, Mr. George. I'm going to let the SAN respond to that. Thank you very much, Mr. George, for bringing that question about.
Well, there are various reasons.
Because I don't think you will even be able to finish the answer before we go on break. Okay. So I don't know. Perhaps we should go on break so that you can have an unbroken stretch. Stay with us, please. We'll be right back. Okay. If you told lawyer.
Good morning, Marina Station and all the passengers. Efficient, it's comfortable.
This development will go a long way in reducing congestion and emission.
The trains are a long-term solution to Lagos traffic challenges.
This is where we take the final, decisions on policies, programs of government. I will have to ensure that, the narration of Lagos as a PLC is taken very, very seriously.
This is a major pedestrian bridge linking Oyingo here to Apapa Road over there.
With this overpass, we are providing what we call permanent solutions.
This place is one of the most dangerous areas at the biosecurity environment.
This can go into the news and every crumbs of your neighborhood.
Our goal is to remain as Africa's model megacity, to move our GDP from the 5-6 position to the 3rd position, and we believe is achievable with all the commitments we have.
Explore the city of Lagos, where dreams are made and possibilities are endless. I'm Adedoja Salamadini. I live in Lagos, inside Lagos.
Okay, welcome back, and our guest is Wahab Shittu, SAN, constitutional lawyer, and we're looking at the question of judges and jurisdictional excesses. And in this regard, caller, we weren't able to address his question, but it will be now, had said, why do judges assume jurisdictions, seeing as Mr. Shittu had explained earlier that it's a matter that lawyers are trained for, they know about this. So why do they take this and these cases on that now could end up in what we are discussing now, namely jurisdictional excesses? And I'd like to expand it, Barrister Shittu, by saying lawyers themselves that goad, maybe goad is not the right word, encourage their clients to, let's go this direction. I would imagine that from what you said, these lawyers are knowledgeable that in going in that direction, you're going to hit this stump of a judicial excess, but they still do so. Again, how conscionable is that?
Well, it borders on professionalism. It also borders on ethical, it also raises ethical issues. Because some lawyers, majority of the lawyers are judged to be experts. In the knowledge of the law. Because they are experts in the knowledge of the law.
Yes. Some
lawyers have the capacity to dress a claim in another robe.
The way you put it, to dress it in another robe. This will be part of tactical.
So when you dress it,
the tactical arsenal,
you dress it in the garb of another robe.
Mm-hmm.
And in order to make it look like a claim that this court can entertain.
Yes.
It is now left for the court to look beyond the curtain and see beyond the smoke screen.
Exactly.
And say, no, you have just dressed, he's a woman. You have dressed as if he's a man.
Exactly.
Exactly. So you are masquerading the claim as if it is this.
So why
it is that?
Sir, the judges, what you've said, excellent. It really makes me happy that is the job of the judge.
Yes, yes.
Are you satisfied that judges are playing this role and are calling out, you know, this kind of, dare I say, quackery.
Yes. If you look at our jurisprudence, our cases, a lot of pronouncements have been made by our the highest court, deprecating some of this behavior for some of our colleagues. And when I'm saying this, I do not rule myself out.
Okay.
I'm not saying I'm a lawyer too, and I'm in that business. So what I'm saying is, but our courts, superior courts, have condemned some of this attitude.
It looks like what you're saying, sir, with due respect,
yes.
is that all is fair in love and in war.
Well, it depends on what kind of lawyer you are. It's not. There's a distinction between a lawyer and a jurist. All lawyers are jurists. You get me? All jurists are lawyers, but not all lawyers are jurists.
Okay, let me bring in Bobby. Bobby has called in from Jalingo and has been holding on for a while. Good morning, Bobby.
Good morning, Uncle Yori.
Good morning, sir. Go ahead, please, with your question.
Let me just go straight to the topic. Sir, we just have to be telling ourselves the truth in the present country that we have as the name Nigeria. The judiciary was actually the last hope of the man before. Certainly not now. They compromise and they keep compromising. The system has failed. And if of this country did not wake up to actually intervene this and do the right thing, we are living as nowhere in the nation. That is just the truth. We should stop playing different kind of things that the judiciary is actually on the right track. May God help us, and great topic you have today on the program. Thank you so much, sir.
Thank you very much, Bobby.
Like I was explaining, and I think this is very important. All lawyers must endeavor to be jurists. What do I mean? They should be more obsessed with the theory of justice.
Okay, okay.
They should not indulge in frivolities. You understand me? And they should respect professional standards.
But a lawyer wants to win his case.
When you want to win your case at all cost, then you are not a jurist, you are a lawyer. That's just simply a lawyer.
Yes, you're a lawyer.
You should be a lawyer jurist.
And that's why we have judges who will call you out.
Even judges.
Judges who will blow the legal whistle.
Not all judges are jurists.
Well, that's a problem right there.
Yeah, all judges must be jurists. They must be obsessed with the theory of justice.
Because you said earlier that this practice we're talking about is, you seem to regret it, but it's prevalent.
No, it's becoming very permissive. But the laws are settled. All of us have access to the law. And we have a duty to abide by the prescriptions of the law. We have a duty to advise our client, no matter how big the size of the client is.
Yes.
The size of the pocket of the client is.
Yeah, exactly.
This case cannot fly.
Well, lawyers don't do that. Uche has called in. Good morning, Uche.
Yeah, good morning, Mr. Yere.
Good morning. Thank you for calling.
Yeah. Good morning, our listener gentleman, Honorable Shittu.
Thank you. Good morning.
Wahab Shittu, S-A-N. Go ahead, please.
Yes, S-A-N. So, my name is Uche. I'm calling from Nnewi.
Okay.
Yes, the S-A-N came up with a point that it's only the court that can declare a seat vacant. I think I disagree with him, even though I'm not a lawyer. I think from my own point of view, it's not the court that should declare the seat vacant. It is the principal officer that should declare the seat vacant. So going to the court, I mean,
Uche, I do beg your pardon. I really do. But on matters of law, we have to defer to the senior advocate in our midst. So when you come along and say that you don't agree with them, I think it just will be noted. But in terms of fact, we have to go with the senior advocate has given us the position of the law.
And if I may just add, all the 3 tiers of government that we have, they have specific rules assigned to them under the Constitution. The legislature is to make laws. The judiciary is to interpret laws. The executive is to enforce law.
Okay. Now, these laws,
Yes.
laws are made for men
Yes.
and not the other way around.
Yes.
So we have a problem here when people don't do what they should be doing. Somebody, I think it was the gentleman who called in earlier, just before Uche, you expect as the last hope of the ordinary man, it is imagined that all other things will be equal. That is to say, the judges will be knowledgeable, will be watching like a hawk, will blow the legal whistle if any infringement is seen. I don't know the extent to which we can depend on this. Lawyers will be honorable, will not be trying to trip up the judicial system or trick the judge, sometimes willingly, sometimes maybe unknowingly. But when it is said that the last hope of the common man is the justice system, and there are so many grenades, so many booby traps, and people are cooperating with a conspiracy of silence.
Okay. Let me say it. In
Is
spite
it
of all these imperfections,
yes,
some of these imperfections we have ruled out, our judiciary still remains the best, not only in Africa, not only in the Commonwealth, but also one of the best in the world.
Aren't you saying that because of
no, I'm not
patriotism?
saying, I'm not saying that. I'm not saying that because of the, we have some of the best legal minds. In spite of some of these problems we have, the system has been rising up to it. Okay. But what I think the agitation should be, we should continue to improve upon the system. I've said so that Justice Liman has made pronouncement regarding the Kano issue. He has made the pronouncement a long time ago. By now, there should be a mechanism that will get the Court of Appeal to intervene quickly. The element of delay.
But we're still waiting.
We're still waiting.
And you people say justice delayed is
so
justice denied.
So we should assign dates for appellate appeals, appellate matters, quickly. We should assign justices to handle appellate matters, quickly. We should resolve issues quickly before they snowball into major crisis. So when a judge sitting alone has made mistakes,
yes,
and that mistake remains the law,
yes,
there should be a fast-track mechanism that will correct that mistake without undue delay.
But they're not putting this fast-track mechanism in place. And
that is the reform that should be the advocacy.
Okay, there's a caller from Abuja. Good morning to you in Abuja. Could you say your name, please?
My name is Adaviriku. Good morning.
Abalebo.
Adaviriku.
Okay, good morning to you, sir. Go ahead with your contribution.
Yeah. Good morning.
Good morning.
Yeah, my contribution is that there is a total collapse of institutions and everything we are looking on to in Nigeria. But the judiciary, as it said, is the last hope that is to adjudicate and dispense law. And that's the hope of everybody. But despite the fact that we agree that we have institutional failure, the system has collapsed. Both the bench and the bar seems to know that there is the judiciary is not working as it's supposed to be. That's why the conflict that we are now witnessing, the judiciary should go back. It is not just mere word saying. It's not just mere of just if by our constitution, our legal documents have defects because of the changing time, they should go back to the drawing board. Because as at now, sometimes judgment is only dispensed and agreed upon when it favors an individual. And that is when you now hear that is the common man, judiciary is the hope of the common man. So if every institution in Nigeria should fail, judiciary should not fail us. And
okay, thank you very much for calling in. Appreciate your call. And this is where you were speaking about the reform.
I think the tendency is for us to reduce the problem, the blame, and put it at the doorstep of the bar and the bench alone. No, it's a stakeholders problem. Everybody has some bit of the blame. Some of the lawyers, some blame can be played at the doorstep of some of the lawyers, some at the doorstep of some of the judges, at the doorstep of some of the litigants.
I was going to add that
at the doorstep of the political elite.
Okay.
The government.
Okay.
So it's a stakeholders problem. We have to now make up our mind.
You know, they say justice delayed is justice denied.
Yes.
I've said that once.
Yes.
But also, I dare say it is felt that if you don't have sizable pockets, your justice, the justice that you shall be able to derive is it is shaky. Meaning that lawyers will apply, in fact, the whole system might apply all sorts of creativity, simply because you can fund it. All sorts of creativity. And then you might, this is where you hear that a person got off on a technicality.
I think we should worry us as a country. We want to have a vibrant judiciary that is corruption-free and that is obsessed with the theory of justice. If we resolve as a people that that's what we want to have, then we should begin to insist on standards, certain reducible minimum standards on judicial appointments and on the quality of our judiciary, on the kind of remuneration that we want to donate or give to the judiciary, on how we can put institutional checks in place to ensure that our judiciary performs better than it is doing.
But at the moment, it is what it is. This is what we have on our hands. Reverend Dominic, good morning.
Chibiore, good morning. Wahab Shittu, one of our best in Nigeria.
Thank you.
Honestly, if you ask the senior advocate there, the question you ask is 100 level question. In law, we have a little knowledge. In law, jurisdiction is 100 level subject in lesson. When you walk into law school, the first thing you know is what is magistrate, what is high court, what is federal court. This is what you study in level 100. But let me say this. I agree with senior advocate that in the law in Nigeria, law school in Nigeria is the best in the world. But you will agree with me that the practice is not the best in the world. Let me give you an information. You know that in Port Harcourt, River State, a lower court has notified what the appeal court said the other day, that the governor of the River State cannot take instruction from the 25 lawmakers. That was a judgment a few days ago on another court in Port Harcourt. What I'm trying to say is this: the problem of lawyers in Nigeria is getting overboard. Why do I say this? Let me take Ibori case. Sir, the senior advocate, he knows this. In London, a lawyer went to prison with Ibori. Why did he went to prison? Because he brought the information to confuse the judge. When will the judges in Nigeria stand up? When a man brings an information of a case to you, like the senior advocate say, masquerade a man like a woman, a judge can say this one is not a man, it's a woman. It's the work of the judge. But to me, the judge are falling into the traps of the lawyers in Nigeria. He knows better. Law practice in Nigeria, if you're not like senior advocate, you may be going hungry. So you can go to court with any matter. But it tells the judge to say, this is right, this is wrong. But the worrisome of it is that when these lawyers go to court, the judges also go along with them and give this kind of judgment that brings confusion here and there. This argument comes to institution. Who built institution? Is it man or the devil? I think the people that build the institution is the people that build the institution that will say this is right, this is wrong.
Okay.
Where we are going in Nigeria legally is bad, is terrible, is confusion, is worrisome. Because politicians can mess around. Other people can mess around.
Okay.
Judiciary can
not the judiciary. Thank you very much, Reverend Dominic. You see, it comes back to the words of the national anthem, trying to build a society where truth and justice reign. Truth and justice. You would expect that in the court system, in the judicial system, those two words, truth and justice, would be liturgical to them.
Well, that's why we have to salute this current administration for asking us to go back to the old national anthem. A lot of people don't even know some people don't appreciate the essence of that.
Because that anthem is asking God to help us build a nation where
failure.
truth and justice reign.
We're talking of institutional failure, corruption, and all kinds of things. And the root of this is collapsing values, core values.
Yeah, if
you want to rebuild, if you want to, yes, you have to rebuild our institutions, rebuild, including our judiciary. We should rebuild our institutions. We should, now what perhaps we are celebrating is we are defining more to wealth without questioning the origin of the wealth. You understand me? In the days of yore, when your child comes home suddenly with stupendous wealth,
yes,
you are careful. You don't even want to touch the money. You want to know.
That was before.
Yes.
That used to be.
Yes. We must return to those values. Okay. And that's what this administration is trying to do.
Okay. Let me bring in our last caller. Mr. Yakub, good morning to you, sir.
Yeah, thank you very much, Shigori. And good morning to my mentor, in person of Mr. Wahab Shittu. Good morning, sir.
Thank you.
Yeah, Shigori, without not taking us from this very particular question that we are talking about, I'm very happy this morning because of this breaking news that I'm seeing in your screen. That tells me that even Mr. Wahab Shittu sitting down in that studio will be very happy, because I remember one time ago he's one of the advocates of this very particular judgment that comes to play now. And then without not missing word, I give kudos to this very particular government in person of Ashwat Bola Ahmed Tinubu. You know why? Why? Because he knows his onions. He does not even sign the executive order because he knew that this executive order may be beat by these so-called governors. He took the matter to court directly that this money should be paid direct to the local government. Now,
okay, thank you very much, Mr. Yakub. Really appreciate your call. No, Mr. Yakub, thank you very much. You've used up your time. Thank you very much. But it's an important subject that you brought about. He's talking about the local government autonomy, that, you know, monies would now be paid directly to the local government, and he's celebrating that fact. But the main topic is the main topic, and we've been talking about that, and judges and jurisdictional excesses.
Even if I think it's also important to mention that this is happening under this administration.
Indeed.
Because it's also important to also mention that this is also at the instance of the Attorney General, who has proactively gone to court to get the Supreme Court to make a pronouncement. I think our Attorney Generals, in various states, you also take a cue from that. We should always seek the intervention of our court, particularly the highest court, in resolving critical questions.
Indeed.
And there is a jurisdiction that we really exercise, jurisdiction to determine constitutional questions. And I think our Attorney General has spearheaded that, and we should continue more of that.
Indeed.
When there is a dispute between a state and another state, or federal government and another state, we should throw up questions for the determination of the Supreme Court to resolve the issue.
And so, to end...
So what has happened now is salutary.
It is.
At least we now know what the proposal is, a reaffirmation of the Constitution.
And it is
credited. Kudos to Tinubu administration. Kudos to the sitting Attorney General, Lateef Fagbemi.
Indeed. And so, to end up on this, you said all hope is not lost. In fact, you said there is plenty of hope. You say you have an implicit trust in the Nigerian judicial system.
Yes, I have.
Even though it does have its flaws.
Yes, I have. You see, some of these worries that we entertain, they are real. But there are mechanisms for addressing these worries. Nobody has no matter how big anybody is, the law is bigger.
Well,
in the sense that if a lawyer has misbehaved, there are mechanisms for dealing with the lawyer.
Yeah, but
if a judge has also
somebody was pointing out
if a judge has misbehaved, there are mechanisms, disciplinary mechanisms.
Somebody was pointing out the Bori
I think
matter.
We should activate also these mechanisms.
Somebody was pointing out the Bori matter, and I know he was implying that had it been here, the judicial way it was resolved might have been different.
Yes.
So these are things that fall under no doubt, because I agree with you that our lawyers rank among the best anywhere in the world. So it's not for a lack of knowledge, but it is the fact that we are here in Nigeria, and people will do with the law as they will. So since as nobody can come from outside to regulate the law.
And I want to say we should replicate the template, the electoral template, the template of resolving election disputes within the shortest possible time. Why can't we? Why must our cases drag on and on? Drag on and on.
Yeah.
Why must any case take more than 1 or 2 years to resolve?
Well,
the difference between our own system here and the developed economies is that their own system is working effectively.
And our own system could work.
Could work.
If we wanted it to.
If we wanted it to work. So I think the advocacy should be, let's make our system work. Whatever are the impediments.
And it goes back to
in terms of funding, in terms of autonomy,
yes,
that is making this process.
And quality of officers.
Yes, officers. And then we need to appoint more judges.
Build more courts.
Build more courts. Fund the judiciary. Grant autonomy to our judicial officers. Insulate our judicial officers from corruption. And then enforce disciplinary mechanisms. Then we must do all those things.
But until then, until all those things are done, you are implying that it is what it is.
It is what it is.
And that is the...
and we should see it as a stakeholders problem. Not a problem for the judiciary alone, but our collective problem to address. Because the success or otherwise of our society depends on us, collectively and individually.
I think that's a fine nugget to end it on, that it concerns, it's not just the courts, it's this whole society. The society will determine the way it wants to be by its conduct and what it will accept and what it will not accept. Both lawyers, both judges, and even the citizenry itself. Well, Barrister Wahab Shittu, I want to thank you very much for coming on and giving and airing this a bit. Yeah, so
you're a veteran, the way you even
Thank you very much, sir. So that we know where the problem is, and we also have known from you that we are not to give up hope.
Yes.
We are not to give up hope.
Yes.
The Nigerian judiciary can be depended upon, but it will go through those reforms if we want it to. And I dare say most people want it to.
Okay.
Thank you very much. Barrister Wahab Shittu, constitutional lawyer, was our guest this morning. We thank him very much for making time out for us. These people are usually very busy people. So that's our program today. Do please join us tomorrow for a fresh edition. I am Yori Folani. Bye-bye for now.